Awesome. Thanks so much, Netta. Happy to be here with you all today. I'm Steve Tinnelly with the Tinnelly Law Group, and I'm going to be speaking about this never ending pandemic panic. So, the information I'm going to be talking with you about today deals with enforcement and operations, some question involving meetings. I know, you know, regardless of where you are in the state, there's some trending that we thought we were coming on the other side of things. Now it looks like there's some more restrictive limitations that are being put in place. So we're going to talk about all of those from a global point of view, and hopefully give you all some information that'll be useful in managing your communities and responding to the concerns of your neighbors. So let's talk about enforcement and operations. And these were questions that our firm was initially getting when the pandemic first hit, and when everybody didn't know what was happening. We're going to shelter in place, what's going on, so on and so forth. And hopefully, we thought by now that some of these things there'd be some normalcy that's returning, and whatever normalcy that has returned, it seems like again we might be moving in the other direction. So all of these questions that were relevant months ago, I think, are still relevant, may become even more relevant now as we move forward into the holiday season. So relaxing enforcement protocols, what the association's role is, when it should not be involved in dealing with pandemic and COVID related issues, and then also our recreational facilities, the constant moving target. Do we open? Do we close? How do we open? Can we open? Should we open? All of that good stuff. So let's talk about enforcement and operations, relaxing enforcement protocols. We know that associations, we have governing documents, we have rules, we have use restrictions in our CC&Rs. These are important things that we need to enforce. Right? That's one of the jobs of the association. But also, we have to put that in context of what we're dealing with right now. And there might be opportunities for us to relax enforcement protocols, or to really say, no, we're not going to get involved in that type of pandemic related issue because it's not the association's mandate. So what this table here shows you gives you some guidance to be able to consider these things. When to be vigilant, meaning when should we immediately address a violation of our governing documents? Unapproved construction is one thing. We don't want someone to complete building or modifying their unit or moving structural walls and wait till that work is done before we address it. It's important that we address it the second that we know about it. Parking restrictions, those are also another thing, especially in condominium communities, right, where we have a finite amount of parking spaces. We have garage use requirements and things along those lines. Right, the pandemic really does make an impact on those, and those are really important, especially in high density product types where the need for parking is more significant than a master plan community with a number of streets. And also collections, assessment collection related things. It's important, as much as we might want to empathize with members that are in our community that have fallen on hard times and might have lost employment. That's all well and good, but at the same time, as boards of directors, we need to be prepared to take the steps to make sure that we secure the debt that's owed to our association by recording liens and things along those lines. And I'll cover that in a little bit later in our talk. Types of use restrictions where we can relax enforcement. Restrictions on play equipment used on member property, single family home communities. I remember at the beginning of the pandemic and to this day, a homeowner had a small trampoline outside, and it's a violation of the use restrictions. But at the same time, I have a father of four small children. I understand we need to get the kids out of the house. And if we can allow the homeowner to maybe have something that we wouldn't have in ordinary times in order to allow them to actually live with the circumstance that we're dealing with right now, that might be an option to do that. And that's part of the broader understanding of realizing that, hey, we're community associations. We're a community of neighbors. If there's ways in which we can accommodate each other during this hard time, we should think about that. Also, violations requiring corrective maintenance. I know it's important for everybody's fences to be painted and things along those lines. But in the grand scheme of things, what we're dealing with right now and the challenges that we're associated with, we might want to relax those protocols, give people more time, more than 15 days or 30 days to address an issue. So when should the association not become involved? Homeowners calling management, right? Or calling you as the board saying somebody was throwing a party and it's in violation of a social distancing guideline and so on and so forth. Those individuals can report those concerns to the health authorities. We're not a law enforcement entity. We don't need to be enforcing those as homeowners associations. This was a novel thing, and I hear some communities are still trying to do it to facilitate shopping programs for people that don't want to get outside their unit or get outside their homes. They say, hey, we'll get the community and the HOA, the condo board will put together a shopping program to allow people to go out and shop. That is more liability exposure than the association should take on. If homeowners want to do that for their neighbors in their individual capacity, that's fine, but we shouldn't be doing that under the banner of the association. It shouldn't be an association organized thing. And then also informing residents of positive COVID cases. Our firm's position that it's not necessarily the association's mandate to do that. And of course, the disclaimer at the beginning of all these things is, hey, this is not meant to be a legal advice. Don't substitute what I'm saying for the advice of the attorney that your community is working with. And I would rely on that advice, whatever attorney you're working with. But from our perspective, we don't think it's an association's mandate when they hear that somebody might have tested positive to go tell the community all about it. So let's talk a little bit about recreation facilities. So at the time we're recording this, I don't know, at the time you're viewing this, it might change depending on the county that you are, but these are kind of the restrictions that are in place right now. And I was looking at it this morning, and if you're in LA County, it might be a little bit different for you. So pools and spas, they're only open where it can be managed or controlled to allow for limited use or periods of exclusive, and we could cover for hours covering over the details. And I'm sure you've worked with your legal counsel with where your community is located to understand all the different nuances, but this is hitting it from a very top level. Gyms and clubhouses, those should remain closed. There is some limitations, some exceptions to do outdoor gyms or outdoor facilities if you want to move your equipment out there, but most communities don't find that that is something that's feasible. So they're closing those at this time, just keeping them open to facilitate basic administrative functions of the association. And also parks and tot lots. I was looking at LA County before we started speaking this morning, and LA County allows parks to be open, but tot lots and playgrounds, those have to be closed currently as of the state of the order. And of course, we have to comply with the social distancing requirements during parks. So when you have all of these rules that are put in place, and as we keep moving to a purple tier, back to an orange tier, and tomorrow might be a red tier, so on and so forth, how do we tell our membership, how do we adopt new rules in order to do that? Fortunately, there's an avenue under the Civil Code that gives us, as boards of directors, the ability to adopt emergency rules without a member comment period when the circumstances change and they require it. And that's something that you also want to discuss with your association's legal counsel. So these are the recreation facilities, just kind of a broader picture that I have, especially for smaller communities. Asking, what's the liability exposure? Do we even have to open these facilities? Yes, Steve, technically we could open our pool, but then we have to have all these different mitigation measures in place, a reservation system, an attendant that's there, and it's expensive. We don't have to, we don't have the resources to do that, and that's a challenge. And just because you might legally be able to open in some capacity, if financially it's not feasible for your community, there isn't an obligation for you to open that. And that's important to keep in mind. You as boards of directors, right, are entitled to rely on information, opinions, reports that are prepared by your counsel and your experts. So when you're talking with legal counsel and they advise you of all these different guidelines and understanding what the costs are associated with trying to keep the pool open to such a limited capacity, there's likely avenues through which you as a board, in good faith, in a manner that you believe is in the best interest of your community, can say, hey guys, as much as we'd like to open the pool, it just doesn't work out that way right now. Financially, it doesn't make sense. The liability exposure is too great. So we need to make the decision. As much as we want to be able to go out to the pool right now, it's just not going to work for our community. And on that point too, another issue that we're getting, and you're probably dealing with this challenge, you'll have members ask you, well, if the pools are closed, if the recreational facilities are closed, if the gyms are closed, I'm not going to pay my dues. This is another issue you want to talk to your legal counsel about, but the big picture is, and this is one of the reasons why I don't like using the term dues. I like using the term assessments. When someone thinks dues, they think it's a membership dues, like a CrossFit gym, to where if the gym's closed, I don't have to pay my membership dues. An assessment is a different thing. Just because the pool might be closed doesn't mean we don't have to pay for the maintenance. Doesn't mean we don't have to pay for the insurance policies that cover us from liability. Doesn't mean we have to pay for landscaping and all these other things. Those are all fixed expenses. So regardless of whether our pool is closed right now because of a pandemic, or it might be closed in the future because we're doing a remodeling job, so on and so forth, none of that matters. The assessments still need to be paid. And having that type of open and upfront communication with your membership, honestly, in our experience, it's been good throughout this process, just letting them know ahead of time. You have to pay your assessments, here are the reasons why, and it mitigates the amount of delinquencies that your community might face, which is better for the homeowner, it's better for your community, because otherwise all you're doing is just spending more money on collection actions that nobody really wants to do. So moving on, let's talk about meetings, board meetings during shelter in place. I know it's not technically shelter in place anymore, but we might be moving back to that. And even if we're not, but social distancing is still here to stay. How do we continue to conduct our board meetings, not only during this pandemic and the next few months and whatever 2021 has in store for us, as well as our annual meetings as well. So board meetings, talk about the Open Meeting Act. Those of you that are watching, that are seasoned board members, you already know, you probably have the Open Meeting Act ingrained in your head, and I'll just cover it from a top level here. The board cannot act on an item of business outside of a board meeting. In order for the board to act, there has to be a board meeting, right? And if it's a certain matter that can only be discussed or acted upon by the board in an open board meeting, well, members have the right to attend and address the board at an open session. Right? Which obviously presents challenges because we're all segregated, we're in different places, we're working from home, there's social distancing, and so on and so forth. And the Open Meeting Act also allows the board to adjourn to executive session to consider and act upon specific type of matters. These are your executive session matters. This table here gives you really a top level breakdown of executive session versus open session. On the left, legal matters, contract matters, so on and so forth. But the big picture here is no member attendance rights for executive session. Members don't come to executive session. That's just for the board and for management and whatever, your legal counsel might be in attendance with you at executive session as well. Under the current state of the law, executive session may be held entirely by teleconference or video conference. So the word we learned all this year, right? Zoom, right? We've been Zooming. We've been doing these executive sessions. No problems under the law to do that. And thank goodness we have these video conferencing tools. I know in my experience, it's actually been nice to learn these tools because we found that our meetings are going more effectively and we're not paying for travel time. And we're able to facilitate a more productive dialogue with the directors because they don't have to drive to a central meeting place or leave their units or leave their homes. Then we have open session, which is decisions to record assessment liens. Those have to be done in open session. And then everything else that can't be discussed in executive has to be done in open session. But the challenge is doing an open session over a Zoom or a teleconference is that the code currently requires, and when I say the code, the Davis-Sterling Act, at least one physical location for members to attend and observe and listen to the board. That's under the current state of the code. So during this whole process, when we've been in shelter in place and so on and so forth, what have we been doing to deal with executive session and dealing with open session? So executive session, like I mentioned on the last slide, teleconference is okay, video conference, Zoom is okay, no member attendance rights, except if you have a member who's the subject to a hearing, you're calling them to a hearing in executive session, you have the member Zoom in. So we like Zoom or GoToMeeting. All these tools have, in our experience, been very effective in us being able to conduct our executive session meetings. But then the question has been, well, what about open session? All right, again, if we need to record liens, certain financial review requirements, the law requires us to do those under open session. And during this, when shelter in place, what do? We've still been doing open session meetings over Zoom. Technically, the law doesn't allow for that because we need one physical location. And we as industry attorneys were put in this interesting position to try to advise our clients. Do we break the law? Do we not break the law? And we think, well, as long as we do this Zoom, but we further the intent of what the Open Meeting Act is. And what is the intent? Board members need to be able to have this open session meeting with the membership having the ability to attend and observe and address the board during open forum. Well, we can do that over Zoom. And we've been utilizing that as a tool. And I have a bullet point here that some of our board member clients have really enjoyed it because you have those fun members that come to the meeting and they don't want to stop talking after their time is done, and they go off on a tangent, and we have that ability to hit that beautiful little mute button and move on to the next person. So can we continue to do Zoom forever? The answer is we don't know. I do know that the California Law Review Commission is currently considering legislation to remove the one physical location requirement, because in reality, through technology, we have the ability to further the intent, to satisfy the intent of the Open Meeting Act, to have members patch into a meeting, and we don't need to do that physically. And in this day and age and dealing with this pandemic, it's more beneficial that we don't. So this following slide here, this last slide, during shelter in place, post shelter in place, executive session meetings, utilize those. If you need to conduct open sessions, limit those and make sure that you have those only scheduled for when you have to do those open session items, and utilize Zoom. Keep in mind too that a lot of what the board does and acts upon can be delegated to management, right? Certain expenditures, certain things. And once those delegations are made, then no board meeting is ultimately required. So if there are options now to where you can give management a little bit more authority to do some things and thus remove the need for the board to meet as often, that's a conversation that you might want to have with management as well. So even during the social distancing requirement, still utilize video conferencing. I don't imagine that this is going to go away at all. I see no reason why the legislature wouldn't allow for this to continue, especially if they're the ones, keeping us with all these strict orders. But we'll see what happens. So currently, the case is, at least for our clients, we're still utilizing electronic meetings, both for executive session and open session. Your community's legal counsel may have a different perspective, however, and it's important for you to follow your community's legal counsel. Wrapping up here, annual meetings, director elections, right? We don't need to postpone these, even though the social distancing requirements and so on and so forth. And why is that? We had some clients say, well, for the ballot counting meeting, we need to have, the law requires us to have a physical location and the members for the members to observe the ballot tabulation. And how do we do that when we have smaller facilities and the social distancing requirement? People are worried about masks, so on and so forth. We're still utilizing Zoom in order to do those. And we'll have the inspector of elections set up a Zoom, and there's a feed, and people can observe the ballot tabulation even though they're not physically there. So we still don't see a need, regardless of whether if we go back into a more restrictive tier and we might have to stay at home again, there really shouldn't be a need to postpone the annual meetings. If you must postpone, there are some certain procedures that you can utilize under the code. You usually conduct it within 60 days and your directors will continue to serve. And these are all nuances that you can discuss with your legal counsel. But big picture, there should be no reason for a community to have to delay their annual meetings, even though we had some new procedures that were at the beginning of the year, SB 323, rewriting election rules. This slide contains some of our resources on it. If you have questions regarding director elections, we're still getting them, as well as if you wanted to build an election timeline to help you plan for when you have to conduct your next election. These links are here and they're available for you. So thank you all so much. I really appreciate the opportunity to speak with you. I hope you learned some information. Be well and stay safe, and we'll see you next year.